Introduction. The state frequently asserts the need to safeguard the integrity of the legal profession. To this, the people ask, what integrity? Historically, the legal profession was regarded as honorable and essential to the foundations of justice. Lawyers played a central role in shaping the rule of law. However, public perception may have shifted dramatically. The profession, to many reasonably minded people, is now widely viewed as greedy, self-serving, manipulative, and in many cases corrupt. This perception does not arise without cause. The reality of the current system based on people's personal experience. The modern legal system has in many respects moved away from the pursuit of truth and justice. Instead, it has become a system focused on money and winning at all costs. Defense representatives may seek to obscure or distort facts to secure acquittals. Prosecutors may rely on selective application or interpretation of the law to secure convictions. Negotiated outcomes with the police and prosecutors allow individuals accused of serious wrongdoing to avoid full accountability in exchange for cooperation, commonly called plea bargaining, which is an anathema to justice. This results in a system where truth is secondary, outcomes are negotiated, justice is compromised. This may all be designed to harm the rule of law. Such a system cannot reasonably be described as honorable, fair, or just. A system at odds with its own claims. Despite these apparent realities, the state continues to talk in terms of honor, integrity, and moral responsibility. The practice of law can be noble. It can serve justice. However, this depends entirely on the conduct of those within it. The following confirmed issues may demonstrate that the current legal system is failing to meet those standards. Confirmed constitutional and procedural failures. Reference is made to the constitutional submission provided to the members of the Scottish Parliament, which outlines a recognised constitutional concern regarding the role of the Lord Advocate and the apparent absence of a separation of powers. The following matters may confirm how these failures are manifesting in practice. 1. Absence of lawful jurisdiction. State courts are proceeding without first establishing lawful jurisdiction. Where jurisdiction is not properly established, any orders issued may be unlawful and void. 2. Refusal to address jurisdictional challenges. Sheriffs are refusing to address challenges to their jurisdiction, deal with preliminary issues raised, and provide written determinations or reasoning for their decisions. The effect being that proceedings are continuing without transparency or accountability. 3. Failure to comply with the Scotland Act 1998. Multiple devolution issues were properly raised concerning the role of the Lord Advocate. The state courts are under a legal duty to address these matters. They are refusing to do so. These apparent structural failures may directly impact the principle of the separation of powers and call into question the efficacy or existence of the rule of law in Scotland. 4. Systemic refusal across all state courts. This issue is not isolated. It extends across sheriff courts, sheriff appeal courts, the Court of Session. Rather than addressing the constitutional issue, state courts refuse to engage or rely on procedural barriers to avoid determination. 5. Abuse of process and arrest powers. In a criminal case, the presiding sheriff refused to address jurisdiction and constitutional issues. They refused to identify the correct defendant and issued an arrest warrant for non-appearance while the individual was present in court and speaking to the sheriff. This occurred after the individual refused to accept classification as a legal person. This seems to confirm that state courts can only deal with legal persons and not real people. 6. Systematic refusal to acknowledge key evidence. State courts routinely refuse to recognize or engage with individuals as living men and women. Discrepancies in identity, including date of birth, challenges to jurisdiction, devolution issues, lawful affidavits and unrebutted evidence, and lawfully issued court notices, orders, and charges for payment. 7. Malicious prosecution and procedural misconduct. Raised criminal charges were issued which demonstrates a clear procedural failure. Police Scotland issued a charge which was then passed to the Procurator Fiscal. The Procurator Fiscal failed to act for over 8 months, despite correspondents seeking to engage with them. Such proceedings should have been commenced within 6 months under statutory law, and a motion to dismiss was lodged by the individual charged due to this time bar. Despite this, the sheriff dismissed the motion, provided no written reasoning for doing so, and no formal determination was issued. Further, the Procurator Fiscal then confirmed they would no longer respond to any correspondence regarding this matter, despite an obligation to do so. The individual was labelled a nuisance, and the matter continues with an active arrest warrant still in place and the case still unresolved, unjustifyingly placing the individual in perpetual fear, alarm, and distress. This raises serious concerns of oppressive conduct tactics and a malicious prosecution. 8. Parliamentary engagement and confirmation of standing. Recently, constitutional concerns were formally submitted to members of the Scottish Parliament. An MSP has recently confirmed that they have reviewed the material. They then signed a confirmation of standing, and have agreed with the matters raised. This confirms that the issue has moved beyond an allegation and into an acknowledged constitutional concern. Further to this, a bill has been raised with the UK Parliament to amend the Scotland Act 1998, which would separate the dual positions of the Lord Advocate. This bill has received cross-party support. 9. Recording of court proceedings in Scotland. It is a matter of public record that digital recording systems were implemented across Scottish courts. However, it is increasingly observed that records may be incomplete or disputed. Recordings are not made or routinely accessible. No independent record may exist. This raises concerns regarding transparency, accountability, equality of arms. These are fundamental to Article 6 of the European Convention on Human Rights. Questions. If courts possess the means to accurately record proceedings, why would any hearing not be routinely recorded? And who benefits when such a record does not exist? 10. The reliability and independence of expert evidence in judicial proceedings. Take notice that a matter of serious concern arises in relation to the routine use of expert witnesses within adversarial proceedings. It is a recurring feature of such proceedings that opposing parties each instruct expert witnesses who, while presented as independent and objective, frequently provide conclusions on the same issues that are directly contradictory and incapable of reconciliation. Where such circumstances arise, the following concern is engaged. If two individuals, each advanced as an independent expert and each under oath, present mutually exclusive conclusions on the same facts, then the reliability of at least one of those conclusions must necessarily be called into question. This gives rise to a legitimate and substantial concern that expert evidence may, in practice, be influenced consciously or otherwise by the interests of the party instructing and remunerating the expert. While the governing framework, including civil procedure rules, imposes a clear and overriding duty upon experts to assist the court impartially, the repeated occurrence of opposing expert opinions aligned with the respective positions of the instructing parties creates a reasonable perception that such independence is not always achieved in substance. Accordingly, the following concerns are formally raised. 1. That the presentation of materially conflicting expert evidence risks undermining the reliability of such evidence as a whole. 2. That the alignment of expert conclusions with the interests of the instructing party raises a question as to whether expert evidence is, in some instances, functioning as advocacy rather than independent assistance. 3. That, in circumstances where conclusions are irreconcilable, there exists a real risk that one or more opinions may fall short of the standard of objective, unbiased expertise required by the court. 4. that the absence of clear and consistent mechanisms to test and sanction such failures risks diminishing public confidence in the administration of justice. For the avoidance of doubt, this notice does not assert, without specific evidence, that any individual expert has acted dishonestly. However, it does assert that the structural conditions in which expert evidence is obtained and presented give rise to a reasonable concern that the integrity of such evidence may, in certain cases, be compromised. The public is entitled to expect that evidence presented as expert is not only credible in form, but reliable in substance. Where opposing experts present incompatible truths, that expectation is placed in doubt. This information is issued to formally record these concerns, to invite scrutiny, and to call for the consistent enforcement of the standards of independence, objectivity, and accountability upon which the proper administration of justice depends. Question: if both prosecution and defense provide expert witnesses who provide opposite opinions, does that not mean that at least one party is paying for an expert to lie? 11. Policing in Scotland trashes European Convention on Human Rights. On the 20th of May 2020, the SNP government minister Lord Advocate James Wolfe QC set up the Police Scotland, COPS, handling and investigation of the vast number of COVID-19 deaths. As you know, the investigation of deaths must be independent, especially of government and its agents, such as here with its direct ministerial report NHS Scotland. This is by ECHRHRA 1999 article, Right to Life and Attendant Judgments. Here there is an intractable conflict of interests. This is stated as deaths that occur at the hands of the state cannot be investigated by the state. The Lord Advocates, Wolfe and Bain, constantly broke this binding legal edict and have been working with Police Scotland on the deaths. These deaths are also covered by the Scottish Work-Related Deaths Protocol, SWRDP, especially healthcare workers such as Neil Alexander. So where is the HSE? It does not look like the Chief Constable, or the Lord Advocate, complies with SWRDP. It applies to other workers and to the public affected by how work activities are carried out, example patients and care home residents. 6 years on from the first COVID death in Scotland and not one has seen the light of day. This is obscene. A gross insult to the people of Scotland. This is not a functioning legal justice system. We do not even have a HM coroner, unlike the rest of the English-speaking world. There is nothing of the legally required independence in the system of investigating deaths or the prosecution system in Scotland. Bain and their cops, the prosecutors are always the Scottish government and cannot prosecute themselves. So the government is unlawfully outside the law and the rule of law. The Scottish government and its agents can in effect kill with impunity, such as with the thousands of unlawful patient safety deaths, the 100 unlawful deaths of babies in the Scottish maternity services every year, and about 10,000 unlawful COVID deaths. Then there are the acute kidney injury deaths which are almost entirely covered up. Operation Tala. In addition to the above, it can be confirmed that Mark Sexton, a retired police constable from Birmingham, and Ian Clayton, a lawyer representing Ethical Approach UK, have submitted numerous complaints to Police Scotland regarding what has become known as the Spiers Directive. This directive was issued by Alan Spiers, Deputy Chief Constable of Police Scotland, and stated, should any officer or member of staff be approached or contacted by individuals requesting assistance in relation to any of the above matters, such requests should be rejected. The effect of this directive was to instruct officers and staff not to accept, record, or investigate any evidence, allegations, or reports relating to COVID-19 matters. Furthermore, members of the public raising such concerns were not to be issued with incident or reference numbers. It is noted that this position extended to complaints seeking investigation or potential prosecution of the Scottish Government, including allegations concerning approximately 10,000 unlawful deaths associated with COVID-19 policies. Conclusion. The matters outlined above may demonstrate not isolated irregularities, but a systemic failure affecting constitutional governance, judicial independence, and the administration of justice within the United Kingdom. Where state courts refuse to establish jurisdiction, refuse to address preliminary issues, refuse to address constitutional challenges, and proceed without written reasoning, placing the integrity of the entire legal system into question. Notice to the people. The people are entitled to transparency, accountability, and a justice system that operates lawfully and independently. This public notice is issued to ensure that these matters are brought fully into the public domain, and the current position is clearly understood. Issued by We the People, Common Law Court, Croon Community. Date, 24th of April, 2026.